And these factors may show that person A is an employee of person B.
My name is Liaw, employment lawyer and the principal of Liaw Chambers.
Section 101C says that in the absence of a written contract of service, you can still be assumed as an employee and therefore be protected under the Employment Act, provided that these conditions are, not say all of them have to be there, but these are the factors that the court will look at. And when you look at all these things, then he may be categorized as an employee. Number one, when his work is subject to the control or direction of another person. So basically, person A who works for person B can control and direct what person A has to do. This is one factor that can show that person A is an employee of person B. Where his hours of work are subject to the control and direction of another person. Person B can tell person A when you need to work. When he is provided with tools, materials, or equipment by another person to execute work, person B provides the tools, provide the equipment that this person A requires to do the work. When his work constitutes an integral part of another person's business, whatever person A is doing is an integral part of the business of person B. When his work is performed solely for the benefit for another person, meaning person A only works for the benefit of person B, he doesn't work for the benefit of person C, person D, person E. When a payment is made to him in return for work done by him at regular intervals, for example, every month, and that payment constitutes majority of his income. So if these factors, one of them or combinations of them, these are all the factors that the court will consider, and these factors may show that person A is an employee of person B. Why this issue comes about is because there used to be a lot of confusion and a lot of arguments regarding whether a person is actually a freelancer or is he an employee. Freelancer, contractor, these are what we call people under the contract for service, meaning I contract you just to provide a service. If you are a person that is under contract for service, not contract of service, you are a freelancer or you're independent contractor. And if you are a freelancer and you're independent contractor, then you are not an employee under the definition of the Employment Act, and you cannot be entitled to the protection and the benefits provided by the Employment Act. You are a contract for service, whatever you are entitled is provided in your contract. But now it's put clearly in the Employment Act. On these factors, the court will say he is not a freelancer, he is not a contractor for service, he's not an independent contractor, but he is an employee under the definition of the Employment Act. And therefore, everything of the Employment Act, we have to comply for this fellow. You must give the leaves, you must allow encashment, you must give maternity protection, you must give paternity leave. It all starts to apply.